The U.S. Court of Appeals for the 11th Circuit issued a decision recently relating to the multi-employer worksite doctrine and the economic feasibility defense. The decision is going to be of great importance for all employers who have operations that are co-located with other employers, multi-employer worksites. I'm Manesh Rath, and we're going to discuss this decision on today's edition of the OSHA 3030, March 25th, 2026. Welcome to the OSHA 3030, everyone. I'm Manesh Rath. For 31 years, I've been representing management side in the field of workplace law, specifically with attention to occupational safety and health law. I'm joined today by my colleague and friend, Ben Idzik, who's going to walk us through this case. And I'm grateful to you for being a part of this today. Ben, welcome to the OSHA 3030.
Thank you for having me. Always a pleasure.
It's my pleasure as well. And why don't we start, Ben, by talking about what we're going to talk about today?
Yeah, absolutely. So we'll start with the facts of the case. We're discussing FAMA Construction versus the Occupational Safety and Health Review Commission. As you mentioned, Manish, the important aspect of this case is the multi-employer worksite doctrine, which we'll get into in some detail.
That's right. And we're going to talk about one of the other defenses they raised, which is the economic feasibility defense. And I think that that's incredibly important when read in conjunction with multi-employer worksites.
Exactly. And I think we're also going to discuss how both sides of this particular dispute address these doctrines. And
finally, wrapping it up with what the 11th Circuit's decision was. Always exceptional when an OSHA law case finds its way all the way up to the U.S. Court of Appeals for any of the circuits. That by itself is newsworthy.
Absolutely. And we'll conclude, as we always do, with a section discussing what you can do, what you should do from the facts and the decisions of this case.
All right. Well, let's crack into this case. Why don't we start by talking about the facts of the case?
Right. So FAMA was a construction company that mainly functioned as a middleman between subcontractors and construction companies. And what it did is it provided roofers for construction companies in their work.
So it didn't really run a roofing operation per se on this particular project, in as much as it was worked more like a staffing agency, sort of, or a broker of roofers. And these are individual roofers whom the FAMA company knew and was able to readily engage to this project.
And on the particular occasion that centered around the situation in this case, FAMA obtained a contract to provide roofs for a townhouse development in Georgia.
Dawsonville, Georgia?
That's right. Dawsonville, Georgia. And then it's in this portion of the case that the circumstances arise.
Right. An occupational safety and health administration compliance officer or compliance safety and health officer happened to be driving by the site and noticed what the compliance officer believed were two alleged violations.
Two alleged violations of the fall protection standard. The compliance officer drove by and noticed that the workers were working without fall protection on the roof, which prompted him to begin a inspection of the work site.
Right. Also, the absence of hard hats. So the inspector sees what he believes to be alleged violations and gets out of his car and walks on site and conducts an on-site inspection.
Right. And like you mentioned, the inspection did result in two citations being issued, one under the fall protection standard and one under hard hat standard.
So the inspection results in two citations being issued alleging violations of hard hat violation and fall protection. And when the compliance officer gets back to his office, he does a history search and finds that FAMA Construction has been cited for additional prior alleged violations that are similar, fall protection or hard hat usage.
So when we discuss after the citations are issued, FAMA proceeds to contest the citations.
A timely issuance of a notice of contest,
right,
which is good. They did it right.
Right, within the 15-day working period, as we always discussed. And the citation challenge raised a host of objections specifically to the multi-employer worksite doctrine. And also, like you mentioned, the folks at FAMA raised the economic feasibility defense.
These two defenses, FAMA Construction prosecuted all the way through the process before the administrative law judge. And the administrative law judge affirmed the citation, rejecting FAMA's argument that the multi-employer worksite doctrine should not apply because, given the role that FAMA played, FAMA's argument that the multi-employer worksite doctrine imposes a vague and unspecific, sufficiently unspecific expectation upon FAMA that it shouldn't have reasonably been expected to know what its requirements were. The administrative law judge rejected that argument.
Right. And so as a result, FAMA then appealed the ALJ's ruling to the full commission.
Right. The other argument that FAMA raised was that it's just not economically feasible as a mere broker of individual roofers' services. It's not economically feasible for them to actually assume the duties of a controlling employer.
Mm-hmm.
And that the administrative law judge, that argument, the judge also rejected.
Absolutely.
So then, as you say, Ben, FAMA appealed to this to a full commission. This is the Occupational Safety and Health Review Commission.
And what was interesting about the appeal that FAMA raised to the commission is that it really focused on two aspects of the ALJ's decision. One is the aspect of whether FAMA was indeed the controlling employer under the multi-employer worksite doctrine, and two was the economic feasibility defense. It also used a sort of broad language means of incorporating all the arguments broadly that it raised before the ALJ. And as a result, the Occupational Safety and Health Review Commission affirmed the ALJ's ruling on those two specific arguments that were raised.
So it goes back and forth, back to the ALJ, and then they appeal it again to the commission, and the result is the same.
Mm-hmm.
And then they appeal it to the 11th Circuit, the U.S. Court of Appeals for the 11th Circuit.
Right.
Let's talk about their arguments one at a time, a little bit more in depth, Ben. Why don't we start with the multi-employer worksite doctrine and their challenge to that doctrine?
Right. So just broad strokes, the multi-employer citation doctrine applies to all employers at a worksite where two or more employers are performing tasks that contribute to a common project. So this, I think the simplest example that we can look at is in construction when you have a development and there's different contractors that are involved in roofing and electrical work and plumbing and so forth.
Right, it's true. And we do a lot of work representing construction firms, and they're almost always multi-employer work sites. But a lot of our work is also in manufacturing and the distribution sector. And there too, you will find that virtually every establishment has other employers' employees on site. So it's difficult to imagine very many work sites that are not at some point in their day, week, or month a multi-employer work site.
Right. So once the multi-employer citation policy is potentially applicable, OSHA runs through a two-step process to determine whether an employer under that policy can be cited. And the first step in that inquiry is determining whether the employer is a creating, exposing, correcting, or controlling employer.
So according to OSHA, and this is a agency-created doctrine, it is not in the rulemaking. It did not go through the rulemaking process. It is certainly not in the Occupational Safety and Health Act, so Congress didn't have any opinions on the question. OSHA, the agency, just on its own, spontaneously, developed in enforcement guidance. It developed a theory or doctrine that it's not just the employer whose employees are exposed to a hazard that OSHA should be able to cite. They should also be able to cite any one of four classes of employers. They are, as you said, Ben, creating employers, those who create a hazard, exposing employers, those who know that there is a hazard and they send their employees into exposure, correcting employers, which are employers who have the last opportunity or last reasonable means of correcting a potential hazard, and then, as you said, controlling employers, and those are the ones who control employees or other aspects of the work or the hazard.
Mm.
And if OSHA believes that an employer is any one of those categories, then under the multi-employer worksite doctrine, the agency has said we don't really need to have a situation where you, the creating, exposing, correcting, or controlling employer, have exposed your own employees to a hazard. You just have to be in one of those categories. And some employee of some employer has had exposure or potential exposure.
Right. So the primary issue at this case is that since these contractors that FAMA retained to provide roofing for the Georgia development weren't the employees of FAMA, the issue was whether under this doctrine FAMA was considered a controlling employer.
Right. So in this particular case, it's the controlling employer part of the multi-employer worksite doctrine that is in play. The other argument, Ben, that FAMA raised was this idea of infeasibility. There are two types, you should all know, that there are two types of infeasibility arguments. One is a technical infeasibility argument, and the other is an economic infeasibility argument. FAMA chose to raise an affirmative defense of economic infeasibility. Ultimately, this is where the case will be remembered.
Mm.
But it's important to understand that the economic infeasibility defense here in this particular case was raised by FAMA as inextricably entwined with the idea of the multi-employer worksite doctrine. The idea that an employer who's a allegedly controlling employer is supposed to provide for some kind of control over the employees, even if those employees are not the controlling employer's employees, requires the use of the multi-employer worksite doctrine. And what FAMA argued was this was not going to be economically feasible for us. The expectation that we're supposed to control workers not our own would have been economically infeasible for us. And that was essentially their economic infeasibility defense.
Right. As we'll discuss later on, I think the thrust of the facts of this case with that argument is that FAMA said that the only way that we could control the safety practices of these contractors is if we ourselves retained a supervisor to come on and monitor for safety practice, which would require them to hire an additional employee, which they estimated at around $50,000, which they said that they could not afford.
Right. Two other points that you've raised, Ben, when discussing this case. This is an affirmative defense, which means that the employer, if they're going to argue economic infeasibility, the burden of proof shifts from OSHA to establish the four prima facie elements of violation, which you and I have talked about so many times on prior episodes over the past 13, 14 years of the OSHA 3030. Now that burden shifts from OSHA to establish the possibility that all prima facie elements have been met back to the employer who's asserting an affirmative defense. And now he has or she has the burden of proof to establish the elements of that affirmative defense. And as you said, there are two really critical elements here, and that's that the standard would have been impossible or would have rendered the performance of the work impossible, and that there was some other alternative method that the employer did take in the face of the economic infeasibility. They did something else to assure the same degree of safety or health.
Right. Or that no such steps were available in practice.
Right. Thank you. The other thing that's important to understand about the economic infeasibility defense is that it is essentially irrespective, it is raised irrespective of whether or not the bona fides of the allegation of a violation can be established. That is to say, whether the prima facie elements of a violation of a standard can be met by the agency with or without those prima facie elements in place. Nevertheless, the employer is arguing a citation should not be issued because it was economically infeasible. That's the essence of a economic infeasibility affirmative defense. Okay, so let's talk about FAMA's arguments.
Yeah. So FAMA's arguments, the 11th Circuit, was that the OSHA's definition of a controlling employer violates the Administrative Procedures Act. And like you mentioned, Manesh, this is, I think, sort of one of the main causes of frustration among some employers is that this doctrine was not promulgated through rulemaking. It was issued through guidance and an enforcement policy at the agency. So there was never a period through which employers could comment on the policy, provide their feedback and criticisms of it. And it also argued that the practice of this policy is not uniformly enforced throughout employers. It's something that OSHA does, FAMA in this case, argued whenever it feels like it. And it also went through other arguments saying that the definition of controlling employer is overly vague. It provides the agency with too much discretion to determine whether an employer falls into that category.
Right. And the other underlying implicit argument that's being presented here by FAMA is if an agency in the rulemaking process wishes to enforce a standard against an employer, the expectations in that standard should be so sufficiently clear as to provide the employer with a fair opportunity to know what's expected of them and what compliance would look like. And what FAMA is arguing here is that when you, the agency, say that any employer who's a controlling employer might be liable for example, the fall protection requirements, we don't know whether we're a controlling employer because the definition is quite vague. It's so vague and ambiguous as to leave us unable to answer the basic question, does that cover us? That is the essence of FAMA's argument.
And specifically with that, what FAMA argues is that under its reasonable interpretation of the definition controlling employer, the term should be reserved only for general contractors, folks who have general control over the work site, or contractors that actually have employees on the work site. In this case, FAMA was neither.
Right. It's essentially saying, look, we just brought people onto site and we get paid for that service, and to expect us to be a controlling employer because of that is unrealistic, but it's also vague and ambiguous as to when to know how much we have done in order to achieve that status. And that really flows right into the economic and feasibility argument that when they say all we were paid to do is to bring roofers to the job, we didn't bid, they're arguing, the pricing for supervision as well.
Mm.
Okay. Let's talk about the 11th Circuit's decision.
The decision of the 11th Circuit went straight to the heart of the OSHA Act, and it said that as a principle, barring extraordinary circumstances, federal courts are not permitted to review objections to citations that were not raised before the commission itself. And if we recall from the facts of this case, FAMA brought the objections to the multi-employer citation policy mainly in its ALJ decision. When it appealed the decision of the ALJ to the commission, it only raised the two arguments that we discussed. That is whether it was a controlling employer and its economic feasibility defense. It did not bring the arguments as to vagueness, as to the rulemaking procedures. It did not bring those arguments to before the commission.
Specifically, the only argument that it raised to the commission was the economic feasibility argument. And it's an open question as to why FAMA chose not to raise its arguments about whether it was or was not a controlling employer or whether that's fair as a application of the multi-employer worksite doctrine. Why it didn't raise that before the commission and only raised its economic feasibility argument is an open question. I personally don't understand the decision. But what the 11th Circuit said was that you don't preserve the record simply by raising it at argument before the judge, but not before the commission. If you've lost or dropped an argument when you raised it to the commission, that is the level upon which we are performing our review at appeal.
Mm.
And so it's only the arguments that were brought before the commission that we there's within the scope of our review. And so that's lost forever. And I think that was really a very difficult to understand strategy or decision on the part of FAMA, and then to raise it again before the 11th Circuit when they should have known that they had lost or dropped their argument is mystifying for me, frankly.
Yeah. And I think just to build off that point, Manesh, what FAMA did with this broad argument of, well, we raised it by incorporating all our arguments that we raised before the LJ. It's important to know for folks moving ahead that that is not enough to preserve the argument for review by the federal courts. You have to go through the whole life cycle of the citation contest, maintaining your arguments up and down the chain.
That's right. So the 11th Circuit decided upon review that as to the economic and feasibility defense, the only issue that had survived for 11th Circuit review, that the argument as raised by FAMA improperly assumed that hiring a supervisor was the only way to protect workers from hazards on the work site. FAMA had argued if you are citing us as the controlling employer, then in order to perform the job in a manner that is assuring that all of the workers on site are in compliance with the fall protection standard or hard hat standard, we would have had to have hired a supervisor to provide nonstop monitoring for compliance. And that's just not economically feasible. And the 11th Circuit said the assumption that hiring a supervisor is the only way to protect workers from hazards is a flawed assumption. We don't accept it. And therefore, you haven't met the burden. Remember what we'd said earlier, that it is an affirmative defense, and FAMA has the burden to establish infeasibility. And so they needed to do a more exhaustive analysis. And remember also that as part of the economic feasibility defense, the employer is required to show alternatives to the specified compliance methods in a standard. And so the 11th Circuit, grabbing on those two principles of an affirmative defense of economic feasibility, said that FAMA's assumption that hiring supervisors is the only way to achieve this was an improper assumption. And so they said that they hadn't met their burden in establishing the affirmative defense of economic infeasibility, and thus the citations were affirmed, that the administrative law judge's decision and the commission's decisions were affirmed. And that, I think, makes this an incredibly important decision in the world of the multi-employer worksite doctrine. Essentially, that the economic infeasibility defense will require a much better presentation of a defense than FAMA had raised in order to prevail. And also, I'd say that any challenges to the multi-employer worksite doctrine remain in play. They have not been ruled on at this stage. At such time as it comes up all the way up again to a court of appeals, and it may be many years from now under who knows what case, I hope that a strong argument is made that in order to impose these expectations of employers, a great deal of clarity needs to be attached to this doctrine, and that the doctrine could be certainly improved upon if it survives at all, in order to be enforceable. But that day is not today. It's not under the FAMA decision. By dropping the argument before the commission, FAMA had permitted the 11th Circuits to uh, address only the economic and feasibility defense. All right. Well, with that said, let's talk about the FAMA decision and how we can learn from it. What employers should do in light of this decision.
Yeah, so I think first a good takeaway would be to if you're in a position of being a general contractor, make sure you go through the process of reviewing through the RFP process what safety policies and practices are in place with potential subcontractors before engagement.
Yeah, I think that's right. Any contracting party should, as part of the RFP process, ask bidders to present in their bid what their method is for achieving compliance with basic safety and health practices. What are the hazards that they anticipate, and what are the methods they're going to be using to address them? The second thing I'd say is that both general contractors and subcontractors should be expected to maintain their own safety and health programs and retain their own records as appropriate,
Mhm.
because it will not avail a subcontractor to rely on a general contractor safety program.
Mhm. And also, I think building off that point, Manish, you want to make sure that in the contracting process between contractors, make sure that responsibility for safety monitoring is discussed in the contract and is properly allocated by it to avoid any ambiguity.
Yeah, that's right, Ben. And one of the most important things we can talk about today. And in addition, that to use the RFP and bid process to allocate accountability for monitoring activity.
Mhm. And then I think another aspect of this case to keep in mind is that when you're contesting citations, ensure that when you're working with counsel in that process, that all possible arguments are preserved for the record for appeal.
Right.
Uh,
Yeah, I think that's one of the legal arguments that we can learn from this case. The other is when you're facing a citation, it's imperative for the employer, together with counsel, to press the agency for a clear recitation of what are the alleged violative conditions, what is the cause of action, what are the theories of liability, so that it doesn't shift during the pretrial stage. The pretrial stage should be used to narrow that down, define it, clarify it, so that there's a better record for appeal that you were just talking about. All right, well, that's today's OSHA 3030. We have sister programs, as many of you know, the Reach 3030 and the Tosca 3030. The Reach 3030 coming up on April 8th at 10 a.m. Eastern Time. Please make sure you forward on the good word about the Reach 3030 and the Tosca 3030 to your colleagues who are responsible for compliance with those regulatory schema so that they can tap into these great programs hosted by our talented colleagues here at Keller and Heckman. Our next program, the OSHA 3030, will be held again on April 29th, 2026 at 1 p.m. Eastern Time. We hope that you tune in. We also continue to ask you to forward your email invitations to this program onto at least 3 others at other organizations and at your organization, both safety professionals as well as in-house counsel responsible for compliance with safety and health. This is one of the most important things you can do to help keep the OSHA 3030 alive for hopefully another 14 years. Well, on behalf of all of the staff here at Keller and Heckman, whose tireless work helped make this program successful, on behalf of my colleague Ben Idzik, and on behalf of myself, I want to thank all of you in the OSHA 3030 community for making this program work. We are grateful to you for not only participating, but also for spreading the good word by forwarding the email on. We look forward to seeing you again next month. And until then, stay safe.